This is Michael Popok, and by the looks of things, it's Legal AF After Dark time. Huge hearing in front of the United States Supreme Court, an oral argument about whether a major count against Jan 6 defendants used by the Department of Justice and against Donald Trump for obstruction of an official proceeding is going to survive if it was improperly charged by the Department of Justice and needs to be stripped away from everybody's indictment, opening the floodgates to possibly releasing these yahoos who were insurrectionists who attacked our Capitol. You want to know more about the oral argument? What side was Kagan on? What side was Chief Justice Roberts on? How did it all line up at the oral argument? Learn more on Legal AF. Take a listen.
This is really a critical oral argument, and it's regarding the case Fisher versus United States. Fisher was a violent insurrectionist who was found criminally responsible for a number of crimes, including 18 U.S.C. Section 1512C, which had been one of the more potent tools used by the Department of Justice to prosecute insurrectionists. And the question, as framed by the United States Supreme Court, was whether the U.S. Court of Appeals for the District of Columbia Circuit made a mistake in construing 18 U.S.C. Section 1512C, which prohibits obstruction of congressional inquiries and investigation to include acts unrelated to investigations and evidence. When the Supreme Court kind of even frames the question like that, you can tell that I think they're inclined to feel a certain way that the DC Circuit may have erred, even though I don't think that's the case. But two of the charges against Donald Trump, in addition to this being a charge that it carries with it a 20-year sentence, many of the insurrectionists have been sentenced based on this. But if you go to the statute, two of the charges for Donald Trump are under 18 U.S.C. Section 1512. And here's what it says. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. So the Department of Justice is saying, look, take a look at the statute, go to 18 U.S.C. Section 1512C, and if you look at sub 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, that's a catch-all, and clearly the insurrectionists engaged in obstructive conduct to impede an official proceeding, which was the counting of the electoral votes. The argument by the insurrectionists is that no, subsection 2 is connected to subsection 1. And when you look at the language otherwise obstructs, influences, the word otherwise refers to otherwise altering, destroying, mutilating, or concealing a record, so that they're attached, and that unless the underlying conduct involves destruction, mutilation, or concealing of a record, like when the statute was first passed in response to Enron document shredding, then it doesn't apply. Popok, I want to get your take on it, but I've seen a lot of legal commentators say this, and this is kind of where I agree with them, which is even if the Supreme Court finds that 18 U.S.C. Section 1512C doesn't apply to a lot of the insurrectionists, the charge would still seem, to me at least, to still apply to Donald Trump, because his conduct was document-based, evidence-based, submitting fake elector votes. And so to me, the statute still applies to him. What it wouldn't apply to potentially is the insurrectionist who just storms the building, who has nothing to do with the document, but Trump was manipulating documents. Now it still causes delay, and there'll be motion practice if the Supreme Court ultimately says that 18 U.S.C. 1512 doesn't apply. But you were watching the oral argument. You've done a hot take on it. What do you think the Supreme Court does, and how do you think it impacts the insurrectionist cases and the Trump case?
Well, let me start with the Trump case. Even if the 4 or 5 right wing, because it looks like Alito, Thomas, and Gorsuch are definitely not going to vote for having this statute which came out of the 2002 Enron scandal, apply to the Jan 6 defendants who attacked the Capitol to stop the official proceeding, in this case, the congressional count of the electoral certificates, because they're going to tie the two subsections of the statute together tightly and say that the otherwise impairs and impedes has to be something similar to the destruction of documents or evidence. That's how the statute got on the books originally. Arthur Andersen, a now defunct for good reason, auditing and accounting firm working with Enron, their client, they were like shredding and deleting and destroying and spoliating documents to impede a government investigation as to how Enron collapsed, which was sort of the FTX of its day. Sort of FTX and Madoff combined was Enron, and that was the obstruction. But that doesn't mean it only applies in exactly the same types of scenarios. I mean, the Racketeering, Influence, and Corrupt Organization statute, RICO, including the one in Georgia, was supposed to be to combat organized crime, primarily the mafia. We use it for lots of different things now, having nothing to do with organized crime. So that's okay. So those guys, Gorsuch, Alito, Thomas, no, they're not going to vote for that. They're going to vote to overturn the Court of Appeals for the District of Columbia and its decision, led by Judge Pan again, who's quickly becoming, even though she's a new judge there, quickly becoming quite a star on the DC Court of Appeals. Roberts was sort of, you could see him like his wheels were turning and the smoke was coming out of his ears about it. I think he finally got right with the Solicitor General's for the United States' position that if you read them together, it's not a dragnet, that the catch-all is not a dragnet to catch all bad conduct. It was specifically drafted in a way that there is obviously other things that the Congress was concerned about that they couldn't enumerate particularly, but they wanted to criminalize about interference impeding an official proceeding. And rather than try to sit down and cogitate about the list of things that goes a mile long of everything you possibly could do and anticipate it, you just put a catch-all in. I think he got right with that. Certainly Kagan, who led the charge for the left side, the Democratic side of the Supreme Court, in her questioning, is going to be joined on upholding the statute's application to those Jan 6 defendants, along with Ketanji Brown Jackson and Sotomayor. Kavanaugh and Amy Coney Barrett were kind of quiet, and so I think it's 4-4, and the question is, where's Roberts going to be? Even if they were to strip this charge away from 350 Jan 6 defendants, think about the floodgates there. There's been 2,500 or so Jan 6 defendants. 350 of them had this charge against them, some of which have already been convicted, and served their sentences. It's been so long. So they're the ones that are going to serve their sentences, they're going to have their sentences vacated and expunged and all of that. Those that are waiting trial will have it stripped away from their indictment. If it's the only part of their indictment, they'll be released. And so that's all of that. Now, some people are worried. We're worried because 2 of the 4 counts against Donald Trump, who is the sole defendant in the DC election interference case before Judge Chutkan, are for this very same 18 U.S.C. 1512. But the credit, of course, goes to Jack Smith, who already anticipated. He knows what's up at the court's docket, and he knew when he filed his immunity brief for the oral argument on the 25th of April that he better address that. And he said, even if this court were to, for instance, find that 1512 doesn't apply to the Jan 6 defendants in the Fisher case, it doesn't do a darn thing to the 2 counts against Donald Trump, because even if you were to find that it requires some sort of mutilation, destruction, or a drowning and strangling of documents, we have that with Donald Trump in the fake elector certificates. And so since he tried to use the fake elector certificates as a substitute for the real elector certificates, that is, even under any interpretation of 1512, that would fall under 1512 C1, not 2, or one, not two, and therefore nothing should happen. Now, having said all of that, if the Supreme Court rules in favor of Joe Fisher, this former Pennsylvania cop who put on his social media things like a dead congressperson can't certify, one who's not breathing can't obviously one intending to interfere with the official proceeding. If they fine for Joe Fisher and therefore open up the vaults and let all these people out, then Donald Trump, when that case restarts, assuming immunity goes against Donald Trump, and which we think it will, and the Department of Justice is back up and running in the Chutkan case, when she reconvenes the parties after she gets the mandate from the Supreme Court late May, early June, before they go away on summer vacation, the first thing that they're going to do is they're going to say, we're going to file a motion to dismiss the two aspects of the indictment based on the recent Supreme Court ruling. She'll have it briefed. She'll have to make a fast decision. It will go up to the Supreme Court unless Jack Smith wants to pull the linchpin, and just cut those two out and just try the case on a conspiracy for election interference. He's going to have to wait until those two counts wend its way through yet another appellate process. And there we go. We don't have, I'm not hopium today. We don't have a DC election interference case before the November 5th election because of this development. So I agree, it ultimately survives, but it'll have to go through a process which will take time that we frankly don't have. Welcome back. See, lawyers talking about things at the intersection of law and politics that they know what they're talking about. That's refreshing. And we do it twice a week on a podcast we call, wait for it, Legal AF. Wednesdays and Saturdays at 8 p.m. Eastern time on this YouTube channel, and then on audio podcast platforms of your choice. If you know all about Legal AF, we thank you from the bottom of our heart for being a part of our audience. Take that clip. You can be part of our ad hoc marketing department. We're building this network with you and for you. Take that clip, send it off to friends and family and people in your life and say, hey, Legal AF, I love this show. Take a listen. Maybe they'll become part of what we do here. If you have no idea what I'm talking about or who I am, I'm Michael Popok. That was Legal AF, and we invite you to join us for our next show. So until my next hot take, until my next Legal AF, until my next Patreon exclusive video, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.